Have you ever made a mistake? If you are an immigrant and that mistake was a crime, you need to listen to this. You not only need the best criminal defense attorney, but you also need the best immigration attorney. Let's find out why, no matter what the crime is, you need to have an immigration attorney involved in your criminal defense case. Hi, Anthony Ray here with another video on the Ray Law International channel. At Ray Law International, we help HR, senior managers, and individuals overcome immigration barriers to bring key employees and family members to the U.S. Let's find out if a DUI offense can result in your deportation. First, let's go over non-immigrant status and what that means. Then, we'll talk about how one's non-immigrant status can be impacted by a DUI offense and whether or not one can be deported for such an offense. A person is in non-immigrant status if they are a foreign national admitted to the United States temporarily to visit, study, work, or for business, or even for medical reasons. A conviction for driving under the influence, DUI, by a foreign national can have adverse immigration consequences depending on your situation. The conviction can be a damaging factor in discretionary decisions, including whether the person will be released from immigration detention on bond or found to be of good moral character. A single DUI is not an automatic bar to good moral character, but it can be a contributing factor if combined with other factors. Did you know that a DUI can cause revocation of your non-immigrant visa stamp? And when combined with other factors, DUI arrests or convictions can lead to inadmissibility or deportability, for example, under alcoholic or drug abuse grounds. Because a DUI conviction can be a serious negative factor in your determination, anyone with a recent or past DUI should consult with an expert immigration attorney before applying for naturalization or for immigration relief requiring good moral character. There are just a few ways that a DUI might lead to a charge of deportability, and they all refer to those who are already permanent residents. First, the deportable crime of child abuse. Second, the deportable crime of drug addict or abuser. To prove deportability here, DHS must prove that the person meets or used to meet the medical definition of abuser or addict. That is, the abuse or addiction occurred at any time after admission to the United States, that it involved a federally listed controlled substance, and that a doctor did not prescribe the substance for the person. And finally, number 3, travel after conviction of 2 or more offenses with an aggregate sentence of at least 5 years. Have you been arrested, charged, or convicted of a DUI? Call today. Now, more than ever, it is important that you have an immigration attorney involved in your immigration and criminal case. Get the Ray Law Advantage. Get the information and knowledge you need to have peace of mind. Stay updated on immigration matters by subscribing to our channel and sharing these videos with your friends, family, and criminal defense attorneys. Thank you for the privilege of your time. We'll see you next time.